And good morning, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Adam Bowman. Adam Bowman, could you state your name for the court?
Adam Bowman. All right.
Your Honor, at this time, there's been no offer extended. We do believe discovery is complete, so we're respectfully requesting a preliminary examination date.
People have their witnesses available August 26th.
All right, pause for a second. This is what's called a preliminary examination. Think of it as a courtroom test run where the judge decides if there's enough evidence for the case to move forward. No verdict yet, but it's a critical step. And August 26th is when things will really start heating up.
Preliminary examination will be set in person August 26, 2025, 9 a.m. That is before Judge Washington. Bond continued.
Thank you.
Thank you.
I thought you were going to address bond.
I'm sorry, Your Honor. He did want me to address bond. I apologize. May I address bond?
Yes.
I'm sorry. So Mr. Bowman is only being held on this case. He does have other cases pending, but he does have a personal bond in those cases. He is extremely concerned because he's in WCCC and his semester finals are supposed to take place, he indicates, next week. And he's very concerned that he has a Pell Grant, and if he's not able to complete his finals and complete his courses, he's concerned about the implications in terms of his further education, as well as his Pell Grant status. He really is highly motivated to continue his education. He's willing to do a GPS tether. He's willing to stay away from the University of Michigan Hospital, which is where this allegedly took place. He indicates he does have a place to stay, and he would comply with any other conditions the court would impose.
Response.
We would ask that bond remain as currently set. The defendant has an extensive criminal history, including a prison term for accosting a minor for immoral purposes. He's on the sex offender registry. The facts in this case of law involve him being extremely threatening to staff at the hospital, exposing himself to staff, threatening to rape and kill members of a nurse's family, destroying hospital equipment.
Whoa, did you catch that? We just went from finals week stress and Pell Grants to allegations of threats, exposure, and even death threats in a hospital. That's not just a bond hearing, that's a bombshell. Question is, should medication and mental health treatment be enough to offset this kind of history? What do you think, should bond ever be lowered in cases like this?
My concern, frankly, is the mental state of the defendant to engage in that sort of behavior. I believe that he represents a danger to the community.
May I respond briefly?
Yes, you may.
So he is on medication now. Since he's been incarcerated, he has been seeing CMH here in the jail, and he indicates he is taking his medication and he is stable. And I asked him, would he follow up with CMH, or what would his plan be for continuing his treatment if he was able to be released? And he indicated he would follow up with CMH, or he'd go to Packard Health. So I think that's the biggest difference. At the time of this allegation, he was going to the hospital for a mental health crisis. And my understanding was he was not medicated or being treated. And that was in part why he was going to the hospital in the first place. And then the allegations took place at the hospital while he was seeking that treatment. So now he is being treated. He is being medicated. So I think I had a great meeting with him yesterday. It was very productive. And I think he indicates he's in a better position and better state mentally.
Well, the examination is to take place in approximately 12 days. I am disinclined to change the bond given the allegations that have been made. So most
not guilty by reason of insanity.
Alrighty then. Most bond reduction is denied.
Thank you, Your Honor.
Thank you. Yes, sir.
May it please the court, George Lyons on behalf of Mr. Davis on both files, Your Honor.
And good morning, Your Honor. Amy Reiser.
And seeing you, Mr. Lyons, it does please the court. How are you, sir?
Your Honor, it is always a singular pleasure and honor.
Okay, what are we doing?
If I may, Your Honor.
Yes, sir.
I have two issues. One is that we were just retained. We're still receiving and reviewing discovery. We're going to ask to adjourn this matter. We're also going to ask the court to consider a bond reduction.
All right.
We are opposed adamantly to a bond reduction.
Okay, I'll hear argument in a second, but how much time are we looking at in terms of?
Your Honor, I'm tied down on the 4th. I'm asking for the 911 date.
All right.
I've been listening from the back, Judge.
Probable cause will be adjourned September 11, 2025, 9 a.m.
Thank you.
As to bond, go ahead.
Respectfully, Your Honor, these matters arise out of allegations of inappropriate contact with students whom he was the track coach back in 2016, 2017. My client moved with his wife and family to Florida in 2019. People are alleging that because he is out of state, he might be a flight risk. Let's look at the facts. But reviewing what I have so far, not only did they know the police called and talked to him in Florida. He gave them his home address. He gave them his work address where they came and arrested him. His family lives in Albion, where they have for the last 50 years, where he was raised. We asked that he be allowed to bond out to the Adrian address in Calhoun County. He has no previous juvenile nor felony record whatsoever, Your Honor.
Response.
And Your Honor, this case involves multiple victims that the defendant had contact with and sexual relationships that he developed through his employment at the school. So he exploited these victims. He ended up having a child with one of them. He had to be extradited from the state of Florida. We requested a $100,000 cash or surety bond. The magistrate set it at $50,000 cash or surety on each file in order for him not to leave the state. We do believe that he is a flight risk, so I don't see any reason to release him on a personal bond at this time.
Your Honor, may I correct one thing that she said, or rather explain?
I hope it's about the child.
Yes, it is.
Okay, go ahead.
The child was born when the mother, at age 21, followed him to Florida and had their first child. They had their second child last year when she was 23 years old. So this isn't a part of the underlying body of the allegations, Your Honor. It sounds bad when they put it to you like that. But this child wasn't born out of any activity or contact or allegations when the child was a minor, nor when he was her track coach.
The relationship started when he was your track coach.
That's what I'm. That's what I'm asking. I guess I was going to ask. The relationship started there. The ultimate culmination, which may have resulted in the child,
7 years later,
happened 7 years later.
Yes,
but the relationship was while he was in a position of an educator over this child.
That is the allegation. Yes, Your Honor.
And there it is, the hammer drops. Bond reduction denied. Despite the defense painting the relationship as consensual in adulthood, the court zeroes in on the fact that it all began when he was still in a position of power as a coach. That's the key issue here, not just what happened years later, but where it all started.
Motion for bond reduction, considering all of that, motion for bond reduction is denied. I think the bond is set appropriately, if not, quite frankly, too low, given the circumstances, at least as the court understands them now. So at this time, his bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Simpson. Got it.
Assistant Public Defender Jay Bellinger on behalf of Mr. Taylor. Mr. Taylor, can you please state your name for the record?
Yeah, Gary Taylor.
All right, what are we doing on this case? Because there's a number of things going on. I've got the reason he's in custody at this point is because of a conditional bond.
That is my understanding, Your Honor. I have been able to. I'm sorry, I didn't mean to interrupt.
No.
I have been able to go over that with him. Frankly, Your Honor, we would ask to address that today to the extent that in speaking with Mr. Taylor, he said he really has no good explanation for that. He does advise that were he to be given a test for his consideration of his release, that he would not test positive for anything. He has 2 kids. He works in construction. He financially supports them and would like an opportunity to get out in order to do that.
Well, I want to make sure we're talking about the same thing, counsel,
Certainly.
because I have the violation of his bond conditions, that being in case 5681, which are basically that he didn't go to community correction.
That's yes.
There is then a separate bond violation.
That I'm not aware of.
Okay, so yeah, I didn't think we were talking about that.
Okay, thank you.
Because that there is an Ann Arbor Police Department report. Well, which appears to have been possession of drug paraphernalia and other things.
It's my understanding that he's being arraigned on that this afternoon, Your Honor.
Yeah.
Okay. Then I believe
So,
I was told about that.
I can either handle it or he can be arraigned on it this afternoon, but you guys don't have the reports or anything.
I don't have the report, Your Honor, but I would ask that if the court can handle the arraignment on that today.
Well, I'll tell you what I'll do. Yeah, he's in. This go to the magistrate. Well, but you don't have the information. That's the problem.
I understand, Your Honor.
Nobody has it. So we'll get you both copies of what I have on that. On his one that has a violation, at this point, I'm going to set. We were looking to adjourn these. Is that what?
Your Honor, I was looking to set this for a preliminary examination.
Which one? Both of them?
Both of them, yes.
All right.
However, I mean, given, and I don't mean to interrupt again, Your Honor, given the fact that he has a new case that he's being arraigned on, it doesn't necessarily, I'm going to explain this to you too real quick. It doesn't necessarily make sense to set these for PE. You want to keep those together so we can get the new report and the evidence. Does that sound okay? Sure. All right. So I would just ask for an adjournment.
Gotcha. Okay, so let's do this. I know they're setting, there's a new case that comes down, they're setting the 28th, so I'll adjourn this to the 28th, 2025 at 9. On the Ann Arbor case, but the 5681, I'm going to set his bond where he didn't appear for any testing, and given the violations, I'm going to set his bond $25,000. I'll give a 10% privilege on that. I'll set that. His conditions remain in effect. On his other case, he was given a PR financial transaction case. I'm also going to set that one at $25,000. I'll give a 10% privilege on that with the conditions, and I'll let the magistrate handle it.
Thank you.
Okay.
Thank you, Your Honor.
All right.
When justice and second chances collide, whose side are you on? Drop your verdict in the comments below, because your voice might just be the loudest gavel here. Don't forget to subscribe and keep your support with us, as we bring you more gripping moments where the final word always belongs to the court.